Well, I just received a message from my partner, Carlos Eduardo. He's having an issue right now, just ending a very important meeting, unexpected meeting with a client, and he should be joining us very soon. So I'm going to start the panel. As I said, my name is Filipe Cabral. I'm a partner with Daniman Simpson. Together with Carlos, I run the data protection team within our law firm. As you may know, we do have a very recent data protection law in Brazil, personal data protection law in Brazil, which is pretty much inspired in the European law, the GDPR, and that's the subject matter that we're going to deal with today. Just a brief introduction. I am co-head of the privacy and data protection team within Daniman Simpson. I'm also a member of AIPPI KNET in Brazil. I'm the former head of the Rio de Janeiro practice, and my partner Carlos, he's the current head in the São Paulo knowledge net of the International Association of Privacy Professionals in Brazil. As a brief overview of our law, some relevant dates here, the law was enacted in September 18th. So we are a few days ahead of 1 year anniversary of the law. And on August the 1st, the penalties of the law became in force, which means that the first year of the law, there was kind of a grace period for the companies to adapt to the various rules demanded by the law. And now we have all the penalties in force so that the companies may now be supervised by the Data Protection Authority in Brazil and also by any other authority that may check in relevant rules, such as the several representatives of consumer protection and even, of course, judges may also check into the data protection practices of the company once a data protection owner tries to enforce their rights. Principles of the data protection law are pretty much similar to the principles of the European law. The GDPR, as I mentioned, the Brazilian law is pretty much inspired in the European law, so the principles are basically the same. We do have 10 principles in our law, which do not carry the same names, but they do reach the same rules as the European law. So principle of necessity, principle of transparency, principle of information security, and so on. So they're basically the same. As the legal basis, we also have basically the same set of rules as the European GDPR. You may use a personal data with basis on consent, but also not only consent. Consent, of course, is one of the most well-known legal bases, but also you may treat personal data with basis on healthcare, with basis on a contract, with basis on a legal rule, with basis on a defense of the controller in a lawsuit or in a regulatory administrative procedure. So Brazil does have a specific legal basis that is different from Europe, which is the protection of credit. So whatever you need to treat or to proceed with the treatment of personal data in order to preserve the credit system, you may do so. There is a specific legal basis for that. So, and all the others are similar to the GDPR. There is no relevant difference right now in the subject. As a data protection, as a data subject rights, we also have the same. They have the right to be informed about the data processing activities. They have the right to have access to the information that any data controller handle for them. They have the right to revoke a consent that has been given before. They have the right to portability of their personal data from one controller to other controllers. So basically, the data subject rights are the same as the standard international practices. And in Brazil, we do have penalties as well. So whenever you are found in breach of the data protection rules, you may be fined to penalties that may reach 15 million reais, but also penalties of a notice that you must suspend your data protection, your data processing activities, and also any other penalties of suspension of activity if the data protection authority finds it interesting to do so. As an overview of the Data Protection Authority, the roles of the Data Protection Authority, the Data Protection Authority has already been established in Brazil, and of course their roles are regulation of the law, so they may issue normative acts for regulating any issues in the law that are not clear enough. They have the role of surveillance on data controllers, and they may, of course, enforce administrative penalties, such as the penalties of fines up to 15 million reais. That is something like $10 million. They do interact with all other authorities in Brazil, such as Senacon, which is a consumer protection enforcement body in Brazil. So, and also they interact with international authorities so as to exchange experience and also to establish some agreements, for example, in terms of international data transfers. But the most, they are a very recent agency, and they are working right now with the interaction with other Brazilian authorities, especially those authorities that take care of consumer protection. There is a huge collaboration between the Personal Data Protection Authority and the consumer protection entities within Brazil, since the two laws do interest a lot to consumer rights in general, right? And most of the data processing activities come from consumer activities, consumer controller activities in general. And the Brazilian Data Protection Agency has already fixed that they're going to be very proactive, and they're going to take an educational approach, which means they're not really very concerned on issuing fines. They are much more concerned in creating the data protection culture in Brazil, which means, and I have had a discussion with the coordinator exactly on this issue. I have had a discussion with coordinator of the surveillance team within the Data Protection Agency, and he has expressly stated whenever they find a company that has a small breach of the rules, for example, they have not indicated the DPO, Data Protection Officer, on their website, they're not gonna issue a fine because of that. They're gonna send a simple email to the company, contact the company and say, look, here is the Data Protection Agency, and we could not find any information about your DPO on your website. please correct that small mistake so that we can carry on with our activities on a regular basis. So they're not interested in initiating administrative procedures or even issuing fines for very small breaches of the law. They're much more interested in bringing all the interested party and the companies into the data protection culture in general. So they're going to be proactive and they're going to help small, especially small companies in being in compliance with the law. Of course, whenever they contact a company and they perceive that a company has not conducted a data protection compliance program, so they do not have just a small breach, but they are not in compliance with the law in general, then in this case, they will not be so they're not going to take so easy on the company. They're going to initiate the administrative procedure, and of course, they're going to issue fines or even harder penalties on that company. Coming to the statistics. So a search conducted by Akamai Tech company unveiled that a little less than 40% of the Brazilian companies are already in compliance with the law, which is a small number. But if you consider that the company is really big, we have more than 200 million citizens in general, and it's a continental country with with million companies, and most of them small or medium-sized companies. And we did not have a data protection culture in Brazil so far. So this is a very recent law that demands a lot of expenses from the companies in terms of implementing a data protection governance and also implementing several information security measures. So that it's a huge investment, as you know, it's a huge investment. So they are still struggling to achieve 100% of compliance. But good news is most of the company has already started their data protection program. So although they may not state they are 100% in compliance with the law, they have already taken the first steps toward that goal. The best area of business that in terms of compliance with the law are the banking and the finance systems or companies, which is very comprehensible because the finance sector is very much regulated in Brazil. They were already required by our central bank to have very strict regulation and a very strong information security measures. So they are ahead in this compliance program for sure. And the worst sector in general is the retail. Retail in Brazil is very informal if you're not talking about multinational companies, and the margin of profit is very small, so they cannot afford huge investments, especially those investments that are demanded by data protection programs. So we may say that they are one step behind all the other sectors in general in terms of compliance. Talking about the role of the DPO, we do have, the law does accept DPO as a service in Brazil. Actually, the DPO may be a natural person or even a company, and the DPO may be within the employees of the companies or maybe an external DPO. We are, from our experience, we can see that considering that the majority of the companies are small or medium-sized companies, they prefer to hire outside councils as a DPO. So DPO as a service is a reality in Brazil. There are dozens and dozens of service providers in Brazil, and they work quite well. They are preferred by the company so that they do not have to open a headcount and have an employee hired the entire and full-time job for the service. So they prefer to have an external counsel doing the service. DPO is a service in general. We can observe, since the penalties were enacted in August this year, we could observe a last-minute rush. So yes, we do have many companies that are already in compliance, but as we mentioned with the statistics, this number does not reach 40% of the companies within Brazil yet because of this last-minute rush. This kind of a Brazilian culture to leave things to the last minute, and regarding the data protection law, it was not different. So in terms of our recommendation to those companies, please take care, especially of the data protection title holders' rights. Take care of them, because there is a huge industry of lawsuits in Brazil. So the data protection owners, they are aware of their rights, and they are willing to enforce their rights and to obtain damages if you do not comply with their rights. So if you let the data protection program for the last minute, I would advise you to start taking care of the data protection owners' rights, and so to provide access to their rights, to provide a channel of contact, and of course, to be very clear and transparent with your data protection policy, so that you will not face any kind of trouble with this damage industry, as we say in Brazil. Talking about the damage industry, let's talk about the first lawsuit that we have seen in Brazil. There are a recent research conducted by Folha de São Paulo newspaper found more than 600 lawsuits filed in the first year of the Brazilian LGPD, the data protection law, which proves to be right our assumption about the damages industry in Brazil. So there are a lot of consumers in general. Whenever you have a consumer relationship, you may expect your consumer to check out if you are in compliance with the data protection law, and if you're not, they may be willing to file a lawsuit in order to obtain damages. So you should establish a very good channel of communication with your consumers so as to provide to them access to their data protection information, which means access to the data, to the personal data that you handle for them, to the data processing activities that you conduct with their personal data, the time frame that you store their personal data, the measures that you use to control access within the company, and also the measures that you take to supervise any data processor that acts as a third party in the data processing activities. So all those data protection rules, you should take care and should be very transparent, and should provide all the consumers, especially their rights to access and to transparency in general. Not to mention, of course, issues of security, information security in general, because if you have any negative impact in terms of a data breach, you may be sued by your consumers, or even by representative entities, representative of consumers, in order to obtain damages on behalf of them. We have had a few class actions, most of them against telecom companies, especially during the pandemic, because of the COVID-19 monitoring. That was an agreement from the Brazilian government with the telecom companies. So the telecom companies, by using the GPS information from the cell phone companies, from the users, they could share the map of concentration of cell phones within a certain area, so as to demonstrate to the local government, either municipal government, state government, or federal government, so they could better administrate their policies in general in terms of combating the COVID-19, in terms of checking the neighborhoods that had a huge concentration of population, and also to monitor the concentration of people within restaurants, within nightclubs, or within entertainment businesses in general. So by using this heat map of information from GPS, cell phones, they could be very effective in terms of checking the population behavior during the pandemics and during the restrictions imposed by the pandemics. So data protection representative agencies filed class actions against the telecom companies, stating that they did not have the permission or the consent from their users to share their GPS information. But the fact is, the telecom companies were able to prove within those class actions that they were not sharing personal information. They would give to the local authorities only the heat map, which is aggregated information, not personal information from the user. So you could not identify a specific user or their move within certain area. You could not identify the signal from individuals' cell phones. You would, the government would have access only to heat maps, so they would know the concentration of the population, but not the specific individuals that would be located in certain areas. So those class actions, most of them already reached a final decision in first instance, and decision were that there was absolutely no personal data being processed without the consent of the user. So the claims were denied. We also are finding some class actions by fake associations that supposedly represent consumers in Brazil. We do have a lot of associations representing consumers in Brazil, but a few new associations were created within the last year exactly to enforce data protection rights. And why they are called to be fake? Because they represent just those consumers in general. They are associations created much more in paper, just to supposedly represent a huge number of consumers in Brazil, but to sue companies in general, arguing that they're not complying with the law, they're not in compliance with the law, in order to obtain damages from them, to set agreements, settlement agreements, and to obtain damages from them. But those, the companies in general are being able to unveil the truth and to show that those associations do not represent any class of consumers. So all those fake associations, class actions are being denied currently. And in terms of those lawsuits, either class actions or individual actions filed by consumers, you should know that the Brazilian data protection law adopt the objective liability, which means whenever you have a consumer relationship, consumer service provider or consumer product provider relationship, the liability is objective, which means you will be able to any fault, you will be liable for any fault, even if you did not act in breach of any rules from the data protection law in general. So the consumer must only prove that they have bought a product from you, that you do have a consumer relationship with them. And then if you are found in breach of any of the consumer data protection rights, you will be found guilty and you must pay damages to them, even if they are not proving the effective fault from your company. So these are just a few notes from the lawsuits and the litigation among data protection issues in general. Hi, Carlos. I've seen that you just arrived. How are you doing?
Hi, Filipe. I'm fine. Thank you. I've been here for a couple minutes, but please go ahead.
Okay. If you have any questions, let me know. So, coming to our end here, in terms of their protection, we have a few tips that we may provide to you. First of all is get documented. This is very important because, as I mentioned, the Brazilian data protection law is now in this first phase is concerned about checking which companies have already started their data protection compliance program. So you may even have not finished your program, but you must show to the data protection authority that you have already taken the most important steps toward that goal. For example, you must have a data protection policy duly published on your website. You must have a data protection officer that may be contacted through an easy channel, usually accessed through your website. You may even publish the information about your data protection officer. Be very responsive in terms of data subject rights. As I mentioned, we have a damaged industry in Brazil, and if you are found in fault in relation to any rights of data subjects, you will pay damage to them. So be very responsive. So if you are contacted by them, trying to exercise their access rights, try to respond to them very quickly, usually in less than 15 days. Give to them all the information that I need to get ready to provide to them portability if they wish their personal data to be portable to another data controller and so on. Take care of third-party risk assessment. You are responsible not only for the data protection activities that you handle within your premises, but also for the data processing activities that are conducted by data processors that you hire. So make sure to conduct a risk assessment within all the partners that you do share personal data, because if your partner is found not in compliance with the law, you may be held responsible together with them. So we do have a huge accountability principle similar to the GDPR accountability principle, and you may be found guilty together with them. Regarding the privacy policy, as I mentioned, do publish your privacy policy on your website, and if possible, for the multinational companies, you may think of working on a local appendix, considering that the Brazilian data protection law has a few peculiarities, and considering that your local subsidiary may have different data processing activities from the other companies from other countries, you may will think of a local appendix for dealing with Brazil and the Brazilian local peculiarities of the Brazilian law. And do not forget of handling a training program. Training is very easy and very important, especially now during the pandemics. We do have widespread distance learning platforms. So it's very easy nowadays to conduct a training program, especially a data protection training program. Very easy to make it available to all your employees. And we do recommend that you make it available to all your employees in different levels. So you may, for those that, for the employees in general, you may conduct a very basic program so that they will learn about their data subject rights, that they will learn about their roles or how to react in case of security incident. So very basic information on what to do and what not to do. And for those people from your privacy team, or people that are considered to be focal points within certain areas of your company, focal points in terms of privacy rules, you may conduct a more advanced training program so that they will know not only what to do, but also how to guide their specific areas whenever they have any doubts about what to do in terms of data protection, or whenever they find an incident, what they should do, how to contact the DPO, or how to react on those circumstances. These are just a few tips that we provide to you in terms of the law. Thank you very much. Carlos and I will be here for those last minutes in order to answer any questions that you may have. Thank you. Carlos, anything that you would like to add?
No, I believe you were quite comprehensive in terms of providing this overview. But something that I always like to highlight is that, as any other data protection law, they do not, the Brazilian authority do not demand that the companies do not have any problem with data breach incidents, but the companies need to be prepared to show that it was aware of the law and took the necessary measures according to its context, according to the volume of data processing activities it handles. So it's quite important to get documented regarding what the company did in order to avoid unnecessary exposure, not only in terms of penalty, but also in terms of becoming an unnecessary risk to your business partners. So that's a small remark that I always like to highlight.